Hi, everybody. My name is Britton Morrell. I'm with Kaplan, Morrell, and we're attorneys who help injured workers in Colorado. And today we're talking about 3 social media mistakes that can happen that people do when they've been injured on the job. And we're not talking about fraud. We're not talking about people intentionally exaggerating their issues, their problems. We're not even talking about someone trying to game the system. We're talking about real injured, honest workers who didn't know the rules of the world that they entered when they got a workers' compensation system. It's a world where everything you do, everything you post, and everything you say is in evidence, but even more than that, what people post about you can also come into evidence and be used against you. So here's what most injured workers think when they file a claim. I got hurt, I reported it, the system is going to take care of me. And that is what they think, and that the world that is safe for you and that workers' compensation exists, the adjuster seems nice, and you're going to if you get hurt on the job, you're protected, and it's that simple. And, you kind of think of it, well, it's just no different than filing going to the doctor under my medical insurance. But it's not that simple. The moment you file a claim, the insurance company begins a file on you. And that file is worked on by adjusters, attorneys, investigators, doctors who work for the insurance company, not for you. And one of the very first things that they do is they will hire investigators to do a social media search of you. Facebook, Instagram, TikTok, again, whatever is posted publicly, either by you or by any of your well-meaning friends. That, cute, precocious little teenager niece that you've got and that has no privacy settings whatsoever, she posts a photo of you, whether or not you're even tagged in it, they will start to look at your family to see who in your family posts things publicly to start searching for things about you. And they're not scrolling out of curiosity. They're not scrolling to be your friend. They're looking for the gap between what you told the doctors and what life looks like online. Now, here's the thing about social media. Social media is a highlights reel. We all have been there. Some of us have been there. We're not posting the 3 a.m. back pain. We're not posting the fact that we had to go fix the car again, or that, life isn't good, or that we're having to cut back and make adjustments. We're posting the best of, right? Even if it's brief, even if it's occasional, we're only posting the highlights of our life, okay? So we post the video of the birthday party, we post about the vacation, the moments we're smiling. We're not taking pictures of us on a couch because our back hurts. The insurance company doesn't see a highlights reel. The insurance company is saying, here are exhibits and evidence we can use against this person. And yes, if your profile is public, it's fair game. If you are posted or a photo is posted of you on somebody else's feed that's public, it's fair game. And the reality is, fair or not, that's the reality of the world you're in when you have a work injury. So today I'm going to show you 3 real cases, 3 real decisions by administrative law judges here in Colorado in the workers' compensation, where workers' compensation benefits hinged on what was posted on social media. 2 of them involve cases where social media is used against an injured worker. And the third one changes everything. So case 1 from March of 2019, a worker had been assaulted in his job, and the assault was real. The trauma was real. He developed post-traumatic stress disorder, as you would expect, and he described himself to his doctors as a virtual shut-in, someone who had essentially stopped interacting with the world. His doctors believed him. They evaluated him based upon what he said. Then the insurance company searched Facebook. And what they found was this: a trip to Honduras in March 23rd through March 30th of 2018. And what did the photos show? Him wading in water, him swimming, him dancing, him socializing, him smiling. Now stop right there, because I want you to understand about this moment. Maybe he was having a genuinely good day. Maybe the act of going out somewhere, being around people, being outside helped for at least those few days. People with PTSD, just like people with back injuries, have good days and they have bad days. People having a good day is not a crime, and having a good day doesn't mean you're not injured. But his doctors didn't know about those good days because he didn't tell them. And that gap between what he told the doctors and what he was actually doing is where his case died. His psychiatrist, once the insurance company showed him these Facebook posts, revised his report after seeing the photos. And the conclusion was that the claimant was actively misrepresenting his mental functioning and intentionally attempting to appear much worse than he was. And his case got denied by the judge. The psychological claim was ruled not work-related, not covered under workers' compensation, even though the injury was real, the trauma was real, but nobody had taught him to tell the story honestly, including the good days, the trips, including all of it without having it weaponized against him. And that's not fraud. This is not a man who decided to game the system. This is somebody who entered a system that he didn't understand, and he decided to go without a guide. Case 2, January of 2021. Now, a woman had suffered a workplace injury and was fighting to reopen her claim. She had something called complex regional pain syndrome, CRPS. It's a condition that causes severe and chronic pain, typically in the extremities. And she had told her physician that ever since the accident, she had isolated herself. She kept her curtains closed. She lost contact with the outside world. But her Facebook said something different. During the same period that she was reporting extreme isolation, she was traveling. She was going to Las Vegas. She was going to Kansas City, Santa Fe, Disney World, in Orlando, Puerto Vallarta, Anaheim. She was also doing outside sales work, selling for a product called Zervita Zeal, working. And at the hearing, when she was confronted with her Facebook posts, she admitted that she had overstated her isolation. Now, I want to be careful here because I think what's happening is something that I see often, and that is she was in pain. The pain was real. CRPS is a real condition, but somewhere along the line, she decided the only way to make people take her seriously, to be believed, was to turn it into an all one way, all this and none of that kind of story. She needed to present herself completely, totally disabled, because if she gave any nuance, if she admitted to good days, that would just confuse people. And in fact, the reverse happened. Why? Because they use those good days against you if you're not reporting them. Here's what honest nuance actually sounds like. You say, my life is very different. I am not traveling as much as I do. I don't get out of the house as much as I do. For example, I went to Disneyland with my family, but I didn't do as many rides as I normally do. I sat more than I stood. I went home. I left the park much earlier. I didn't get to the park as much. I was in bed the next 2 days, but it was at least good for me to get out of the house a little, even if it was not as much as I normally would have done. Now, that is the truth of living with a real injury. And that is what believable looks like. What she said instead was, I don't go anywhere. And then a judge watched her walk through Disneyland on Facebook. One of the most important things we do for our clients, and I say this not as a sales pitch, but as a practical reality, is we help our clients never say the words always and never to say never. To say most of the time, rarely, usually, but not that day, because the system is listening, literally, and it is not forgiving of absolutes. Case 3, November of 2023. A woman was working in construction and she fell 4 stories when the scaffold collapsed. And she was filling blocks with gravel when it failed. And she fell all the way to the ground. And then, injured, recovering, fighting for her life and her rights, she had to prove who was her employer, because there were 3 different employers, companies, and none of them were admitting to have employed her. And they were all pointing at each other, each of them saying, not us, not our responsibility, not our worker. She had just fallen 4 stories. She was clearly working there for somebody. And the people responsible for putting her up there on the scaffolding were trying to lawyer their way out to deny that they even hired her. And this is the moment where you understand what injured workers are up against. It's not just about social media. It's about a system with people, or where people with resources and attorneys can sometimes make you disappear, make your employment disappear, as if you don't have any evidence. But she had some evidence. She found the job through a Facebook posting, and the posting listed one company's name, but they gave a different employer's personal address for the contact. She had that posting, and she showed the court photographs from the company's own Facebook business page showing that that second employer was actively working on the job site, supervising the projects, running the operation. She also had her WhatsApp messages between her, daily communication between her and the employer with phone calls, daily communication between her and this company. Proof of who trained her and directed her and paid her, and the judge ruled that the second company was her actual employer on the date of the accident. And they were liable and they were responsible. Social media didn't hurt this woman. It saved her case. And that's the thing I need you to understand. Social media is a knife, and knives can cut in both directions. The insurance company almost always picks it up first, almost every time, but a skilled attorney knows how to pick it up too. Here's the sad truth. By the time people call me, the damage is usually already done. The photo is already taken. It's already been posted. The statement has been signed. The recorded call with the adjuster has already happened. The one where they were told they didn't need a lawyer. And now things are starting to crash. And I have to try to build a case around rubble. So that's why I'm making this video. Not because I need more clients, because this information needs to be free and it should be available to you before you need it. Here's what an attorney does in this world that you cannot do for yourself. We know how the system hears you, literally. When you say, I can't lift anything, what the system hears is, here's someone saying they can't even lift a coffee cup. And all they need is a video of you lifting a coffee cup. And when you say, I never go out, the system expects your Facebook post to look like a monastery. We help you speak the system's language, which means being honest about your limitations, honest about the good days, honest about the bad days, and to be precise about what you mean so that nothing you say can be weaponized against you. We know what they're looking for because we've watched them look for it in case after case, year after year. You are walking into a maze, and the insurance company has walked that maze every single day, and so have their attorneys. And so have their doctors, and you haven't. And you need someone with you who walks that maze every day, just like the other side. And that's us. So if you or someone you know is injured on the job in Colorado, get a guide. Get someone to walk with you. Get someone to navigate this maze. We only charge a contingent fee if we're successful. Our consultations are free and complimentary and confidential. And with that, thank you so much for spending part of your time with me today.